বসে পড়ে, চলে আসে, চলে আসে। So, guys, last class we tried to cover the enforcement and functions relating to EU competition law by the Commission. As we know that if there is a violation of EU competition law according to Article 101 or 102, there can be two types of remedies available, sources of remedies available. One source is the Commission itself, as we know. In the last class, we have covered that there are 7 institutions, and amongst those 7 institutions, the Commission works as the bridge between executive and legislative and judicial body. And by this Commission, there are certain stages through which we could, the aggrieved party could get a remedy for the breach of Article 101 and Article 102. Whereas we also said that today we are to cover the remedies which are available not from the Commission, but from the private enforcement, private individual. It is very, very important to keep in mind that not only you have to you have to focus on the Commission's remedies, but also the private individual enforcement remedies for the breach of Article 102 or 101 in your exam script. Suppose, before I move into the private individual enforcement, let us go through one of the questions that you had a few years back. As you can see that you can have both problem-based questions and essay-based question from this chapter. In 2012, we had one question. It says, the question was like this: Article 101 of TFEU prohibits agreements between undertakings which may affect trade between member states, which have as their object or effect the prevention, restriction, and distortion of competition within the internal market. An agreement is exempt from prohibition of Article 101 of TFEU if it satisfied all the criteria set above by Article 101, subsection 3. Assess how exemptions of Article 101, subsection 3 of TFEU have been applied by the court. So here, what should be your answer pattern? You don't have to only focus your answer on the elements of Article 101 and break down the elements and try to relate that with the case references that you have in your mind, but also you must have a structure in your mind which not only focuses on the problem based on the answer of the question, but also it contains some authentic case references and the authentic way of dealing with a violation of Article 101 by the Commission and the private individual. So in this case, what you should do, you must give an introduction. The question in this question relates to the exceptions of the to the prohibition on agreement which distorts competition within the internal market. That means Article 101, if you want to focus on Article 101, the violations of Article 101, then you see that there are certain elements which, if you satisfy these elements, then you can go to the approach to the Commission and approach the Commission with the application of a violation of Article 101 if you are an undertaking or association of undertaking, or if you are doing any concerted practice in doing this from these 3 sources. If you are doing it, and by the conduct or omission of these 3 sources, if the competition policy or competition law is being hampered, prohibited, restricted, then you can reach to the Commission or the private individual. But however, there are certain exceptions. Even if you violate Article 101, within those exceptions, you will not be, the decision will not be made void by the Commission or by the private individual. So in this case, you have to first contribute to the improvement of production and distribution or promoting technical economic progress, allowing a fair share of resulting benefits for consumers, and indispensable restrictions, not allowing the possibility of eliminating competition law. So So এখানে আপনাদের যেটা মাথায় রাখতে হবে স্যার, any question? এখানে আপনার মাথায় যেটা রাখতে হবে, that is এখানে যে এক্সেপশন গুলো বলে দেওয়া আছে, শুধুমাত্র এই এক্সেপশন গুলো লিখে দিলে কিন্তু আপনার আনসারটা প্রপার হচ্ছে না। You have to go through proper, you have to go through that proper structure, that article 1.1, article 102, the elements of article 101, relevant case references, the exceptions, and the breach of article 101 results you to go to the commission or any private individual. So today we are going to focus our class on the private individual related remedies. So let us move on to the slide. I think there's a tab clicking which I can share my screen, camera, capture, Q&A, showcase, screen share. Yes, so this one. Okay, I believe all of you can see this. So today what we are going to focus is this. Private enforcement. So there are different stages of this private enforcement. Number one, an EU right to damages. And the second point is under this legislative initiative, we have certain elements. Let us see. This is EU caps. We have direct and indirect purchasers. Then we have collective redress. Then we have further legislative initiatives. Then we have the assessment. This is the last point that we are going to focus on. So, sir, under the private enforcement, which is the second type of enforcement that you can have. Before that, we had one enforcement, that is enforcement by the commission. Let me write it down for you too. Commission enforcement. And so, it has been argued that private litigation in competition law should be welcomed for two reasons. First, victims of competition law infringement are compensated. Public law enforcement merely prevents further harm, but not provides certain enough compensation for the aggrieved party. And the secondly is private litigants increase the number of enforcement action, widening the application of competition law. The European Commission has long campaigned. They run different sort of programs, and one of these programs is for private parties to encourage the private parties to bring competition cases in national courts, originally as a means of reducing the Commission's heavy case law. Recently, a private enforcement, especially damages claims against undertakings who infringe EU competition law, has been promoted in an effort to complement the Commission's deterrence-based enforcement strategy. And that should be kept in mind that we will first begin by explaining the contribution of the Court of Justice uh, in increasing or giving the opportunity of damages claims before turning to the legislative efforts that the Commission is seeking to implement. And the first point, which is an EU right to damages, because as we all know that it is one of the main aims of EU is not only to focus on the commission-based remedies, but also to encourage the private individuals to go into their national courts and just seek redress for the breach of competition law of Article 101 and Article 102. And EU rights to damages is that it has long been clear that Article 101, subsection 1 and Article 102 have direct effect. Both of them have direct effect according to the case of Subham, right? We studied that case, BRT versus Subham. It is a case of 1974. According to that case, Article 101 and Article 102 have direct effect, opening the way for parties to seek damages. However, there was very little litigation because of uncertainties about the nature of a claim for damages, and because a national court could not decide on the application of Article 101, subsection 3, which left it with little room for applying Article 101. The second problem, as we saw above, was resolved by Regulation 1 2003. You should write it down. The regulation is Regulation 1 of 2003, which this establishes the direct effect of Article 101. And the first to resolve was in 2001 by the Court of Justice in a dispute that arose from a pub lease, and that case involved someone. The name of the party is Mr. Creeham. He made a contact with the entrepreneur for from Courage, and that is another company. The business was unsuccessful, and Mr. Graham abandoned the lease. He he sought damages for the loss of a business from entrepreneur on the basis that the beer tie prevented him from buying cheaper beer, which would have allowed him to make a profit. In the English court, doubts arose as to whether a party privy to an anti-competitive agreement could claim damages. The Court of Justice enthusiastically affirmed that Graham could claim damages. And when the case returned to the English court, the Court of Appeal awarded Graham 131,000 in damages for the losses he suffered. But on appeal to the Court of House of Lords, the claim failed. So, sir, here, uh, so in this, what is it? Okay, here, it is not only the Commission or the European courts which will provide you the remedies. In this case, Mr. Graham was the owner of a pub, and that owner of a pub made a contract with an entrepreneur, a set of companies which gave him a license to sell beer through a beer tier. So what do you mean by beer tier? It is a contract where two or more individuals or companies or sellers would join together, and they would decide, yes, they will sell this brands of electronics on brands of products in their shop. Suppose if I give you an example, we have an electronic shop besides LCLS, which is called Best Electronics. So we see in Best Electronics they sell the most renowned electronic brands such as Sony, such as General, such as this AC, LG. But however, they cannot sell any product outside those brands because those brands, they joined together, made up a contract which is called tier. Under that contract, which contract has privity, uh, and in that contract, what you will see that there is no flexibility. That means the shop owner does not have the flexibility or the jurisdiction to sell products which does not belong to this set of line of brands. So this is done because they want to maintain their uh, quality, and they want to ensure that there is a unique standard provided to their customers in all of their showrooms. So a best example of that type of contract is this case. And in this case, Mr. Graham made a contract with that beer supplier. And the problem was that the beer supplier was only supplying him with expensive quality beers. So that did not have market at that point of time on that area. So Mr. Graham could not sell the beers, and that's why his business fell down, and he had to close down his shop. So later on, when he asked in between the contract period of time, when Mr. Graham asked for cheaper beers, which have demands in the market, then the beer tier providing company, yes, they said that no, you cannot sell those products because you have to sell these products as per the contract. So those products did not have the point of time. So Mr. Graham rolled up his business, and later on he seek damages because he was made bound under the beer tier to sell only the expensive beer. We did not have market at that point of time, which he thought was a violation of Article 101. Because in Article 101, we saw that if there is an association of undertaking, or there is an agreement between undertaking, which will prevent, distort, or restrict competition. So here, there's an agreement between Mr. Graham's bar. Both of them are undertakings, so they had a contract in between them. So first two elements are satisfied. There's an agreement, and there are two undertakings, and that undertaking restricted competition law because that undertaking only allowed Mr. Graham to sell only the expensive beer which did not have market at that point of time. So therefore, he did not have sufficient amount of flexibility or sufficient amount of open market, or go to the open market to have the lesser price beers to sell, which had actually demand at that point of time. So according to him, this contract between him and the beer supplier violated Article 101 by preventing the competition law. This is what he filed a case in the National Court, and the National Court started in 1031. That means বাংলাদেশি টাকায় কত হয় 1,31,000 ইউরো সে ড্যামেজেস হিসেবে পেয়েছে from national courts. Sir? No, you don't have to quote the facts, or you don't have to quote the damages of that case, but you have to keep in mind the principle from all of these cases that we study throughout our course. Because if you can relate those principles in your answers, you will get good grades. Now, you don't have to memorize the fact, though. You don't have to memorize the damages. You don't have to memorize any other aspect of the fact. But it is better for you if you can give the principle at least. Okay. So let us move on to the second portion. So however, this judgment should be studied from two perspectives. From a narrow perspective, focusing on the facts of the case, it should be then noted that English courts had never doubted that a right to damage for breach of competition law was available. Rather, the question that had been referred to the Court of Justice was whether a party privy to an anti-competitive agreement should be able to seek compensation, because the main principle of illegality in English law meant that those implicated in an illegal venture lost the right to damages for loss suffered, because as we know from the principles of equity, there are different equitable maxims. He who seeks equity must come with clean hand. পড়েছি না স্যার? হ্যাঁ হ্যাঁ আমরা অনেক ধরনের পড়েছি যে equity will not prevent a volunteer to perfect an imperfect gift. এটা আমরা ট্রান্সলেট করেছি। Equity will assist equity. He who seeks equity must come with clean hand. Delay defeats equity. These are the maxims that we have studied throughout our equity and trust courses. And as this guy, that was Mr. Crehan, his hands were not clean at that point of time, according to the court, because he himself got into a contract. The contract was going to be completed. He had that want or desire to get that upper class of the market so that he can sell the expensive beers. But he would not foresee that his beers won't have demands in the long run in the market, and he will have to roll up his businesses in the long run. So he himself was engaged in illegal agreement. So basically, he who seeks equity must come with clean hand, but his hands were not clean. So therefore, obviously, he should be rejected. His application of damages should be rejected. But in this case, in this particular case, his application was not rejected. Even if you see the judgment, there is one paragraph which addresses the point that it suggests that the illegality defense in English law is too wide. However, it is not particularly clear how to identify when a party finds itself in a significantly weaker position than the other. From this angle, it might be questioned whether the claim has much merit, as it mainly allows opponent behavior of the part of the business that have entered into a bad bargain. So if you want to focus on it, there's one consultation paper published in 2002, The Innocent Party Right to Damages. I will give you the link later on. If you go through that consultation paper, you will see that even the innocent party which has dirty hands, that means which the person who did not have clean hands while applying to the court, even they are considered the innocent parties, and they can be granted remedies too. From a wider perspective, a judgment must be seen as a general statement establishing of community right to damages. This is significant because it gives the European and national court a shared role in shaping the law. And the most helpful analysis has been provided by the AP, by one of the judges who has elaborated a framework developed by former Advocate General Van Jen. So we call that case Van Jen and Luz. And he distinguished three elements of damages claim: constitutive, executive, and procedural. So please write it down. One, constitutive, executive, and procedural. So I will write it down here. Constitutive, executive, and procedural. Three elements of damages claims. Okay. Elements of damages. So there are three elements of damages claim: one, constitutive, executive, and procedural. The first part, the first online class হচ্ছে আমি ভিডিও রেকর্ডিং শেষ করে আপনার সাথে কথা বলি হাফ এন আওয়ার নাকি এখনই কথা বলতে হবে? আচ্ছা, কয়জন স্টুডেন্ট আছে? আচ্ছা, Guys, give me 2 minutes. I'll come back.
Sam is Asian therapy Jivo. They are the last আমি একটার সময় আমাকে আবার চলে যেতে
দিয়েছেন
এটা অফিসে
এরা দেখেছিলেন?
হ্যাঁ এটা স্যার যে আমাদের চেম্বারে একটু ভাই করে আসছে তো উনি ক্লাস হচ্ছে
হোটেল অফিস में দিয়েছেন।
হ্যাঁ আমাদের যে করা হয়েছে সেজন্য আপনি
I was assigned to do legal research on arbitration, commercial law, government. I was allowed to do legal research related to arbitration. So Google will identify বসেন স্যার আপনার দেরি হয়ে যাচ্ছে তো ক্লাসে আলাদা করে লেখেননি। একটু বড় করে লেখা
আমি লিখেছিলাম ভাই ছোট করে দিলাম। আমি যে লাস্ট সেপ্টেম্বর করে আসছি ফেব্রুয়ারি।
সরকার নির্দেশন করেছিল এক্সাম পেয়েছিল।
হ্যাঁ
Generally, আমরা suggest করি এটা একটু elaborate করে please give details of the exemption for which you are applying and any observation you may wish to make in support of good application of such exemption. আপনি exemption থেকে seek করছেন, আপনি বলছেন part A সবগুলো exemption seek করছি, because আমি example করেছি। এখানে আমরা suggest করি এই প্যারাটা এবং part A এক নম্বর হচ্ছে contract law. So আপনি বলবেন যে we seek exemption from contract law because I have studied this and I have done cases related to this, so I should be exempt. সেরকম করে প্রত্যেকটা যতগুলো পরীক্ষা থেকে আপনি এক্সাম্পল সিট করবেন প্রত্যেকটার জন্য একটা করে প্যারা ওরা কিন্তু ডিটেলস দিয়েছে। যেখানে আপনি কি বলেছেন হচ্ছে পার্ট এ রিলেটেড এই কোর্সগুলো আমি করেছি, তো এই কোর্সগুলো করার পর আপনি যে নলেজ আছে টিচিং এক্সপিরিয়েন্স আছে সেটা একসাথে লিখে ফেলেছেন, সেটা আলাদা করে লিখতে ভালো। বাট যে তুমি যদি অ্যাকসেপ্ট হয়ে থাকে তাহলে আজ সাবজেক্ট হয়ে যাবে দেখি। বেশি দিয়েছেন ভার্সেস আমি তো আপনাদের আমাদের সাদা কামি ছোট
যা যখন যেটা আমাদের হাতে হাতে
কথা কিন্তু
এটা তো যে 200 টাকা
দেন
200 টাকা কিন্তু ছিল আমি দুইটা দিয়েছি বেসিক অ্যাডভান্স
একটা বেসিক আছে না রেসপন্সিবিলিটি অ্যাকসেপ্ট করা লেটার ডেট নেই
না
একটা
কেন তো
মানে এগুলোকে ইংলিশ
এটা প্লট সো আসলে কাকে অ্যাভেলেবল পাওয়া যায় না তাদের কারণে তো আসলে
I hope next certificate na আছে সবাই কিছু ব্যাংক করেছেন
না স্যার আমি আজকে ছিলাম যে এক্সামে চলে গেল আমারও স্যার একটা থেকে ক্লাস আছে 4 দিন সম্ভব সেখানে ক্লাস থাকে স্যার আমি 3টাতে পড়াই ইংলিশ আর হচ্ছে আপনার ইংরেজি স্যার
চারটা হলো
না
ডিভাইস আইসি
আই রিলেট পড়াই মানে ইংরেজি আইএসসি মানে হচ্ছে এই সায়েন্সটা এটা ছেড়ে দিচ্ছি
ছেড়ে দিতে ছেড়ে ছেড়ে দিলেই না জয়েন করতে পারেন ভেরি বেস্ট অফ লাক আপনি কত প্র্যাকটিক্যালি সব পাচ্ছেন
স্যার এখন আপনি এক্সেপশনের ব্যাপারটা মেশিন ডিসকাস করবেন
এটা আমি না সাজেস্ট করি যে আপনি শর্ট ফর্ম না দিতে ইভেন তো it is almost taken for granted যে আপনি অ্যাপ্লাই করলে এক্সেপশন হবে আপনার 2012 তে না 12 তে তো হবে তো আমি সাজেস্ট করি একটু ইলাবোরেটলি লেখা বিকজ ওদের কাছে তো ওরাল কোনো সাবমিশন দিতে পারছে না দিস ইজ দ্য অনলি থিং হুইচ রিচেস টু দেম এবং ওরা এটা করেই আপনাকে জাজ করবে so I would suggest the exemption part should include change I will suggest for যে এটা দিয়েছেন অ্যাপ্রুভ হয়েছে করতে পারে বাট আমি সাজেস্ট করি
উনি এখানে দিয়েছে সেটা নয় আমি এইভাবে ডাউট করে দিয়েছি
আমি সাজেস্ট করি একটু ডিটেইল ড্রাফট করতে কারণ আমি আপনাকে একটা স্যাম্পল দিয়েছিলাম এই স্যাম্পলের মধ্যে কিন্তু ডিটেইলস আছে আমরা চেয়েছি ডিটেইলস আপনি কেন এক্সাম্পশন চাচ্ছেন এবং আপনি কেন এক্সাম্পশন দেওয়া হবে কোথায় কোথায় এক্সাম্পশন চাচ্ছেন আর এর যেগুলো যাচ্ছে ওগুলোতে কেন আপনার রিলেট করেন ওয়াই ইউর ডট ব্লক আপনি ডট ব্লক করেন বলেই ডট ব্লকে কেন এক্সাম্পশন there is a relation and it says completely what that লিখেছি আর জায়গা লাইন আছে সব বললে তখন ওরা এটা মানে it seems quite risky to be very short exemption otherwise it's good
আমি চাচ্ছিলাম কি করে জাস্ট আমি তো ওদিনে এসেছিলাম বাট আপনি চলে গেছেন আর
মনে হচ্ছে না একটা সম্পর্ক সেট করে অ্যাডভাইস দিতে দেখেন একটু রিটার্ন করতে কিছু সময় লাগে I think don't take that risk it's thank you so guys let us move on with the part just left we were discussing about the three elements of damages by the Advocate General in Vengeance. So here there were three, as you can see from the PowerPoint presentation, the elements of damages claims constitute constructive, executive, and procedural. Basically, after he has pointed out, the first relate to the nature of the claim itself, which must be identical among the member states and which are shaped by the Court of Justice. Executive elements include matters like the test for causation, defenses, and damages. The rule pertaining to these issues can be designed by national courts and legislatures subject to two principles of EU law. First, that the rules are effective to safeguard the right. Secondly, that they are equivalent to compatible claims that are made in national law. Procedural, such as limited periods and rules and evidences, can also be designed by national courts subject to the more lenient scrutiny of the EU law. And the thing you have to keep in mind, one of the relevant cases is Manfredi case. And in this Manfredi case, the Court of Justice took further steps to explain the right to damages and the role of national courts relating to the executive and procedural conditions. This was a damages claim by Italian consumer who had purchased liability insurance for motor vehicles at inflated prices after insurance had collapsed. This was a follow-on claim after the Italian Competition Authority had found an infringement of Italian competition law here. However, the wording of which are very close to Article 81. However, the plaintiff claimed damages based on Article 81 because the claim of damages for breaches of Italian competition law rested with the Court of Appeal, while a claim under Article 81 could be taken to a very small claim court which was less formal, cheaper, and quicker at delivering judgment. The Court of Justice agreed that it was plausible to find that the cartel affected trade between member states, allowing the application of Article 101. It then gave some guidance on the role of national courts, suggesting that in the absence of community rules on matters such as jurisdiction of national courts, limitation periods, and the measures of damages, it was up to the member states to ensure that plaintiff received adequate safeguard, provided that such rules are not less favorable than those governing similar domestic actions, and principle of equivalence, that they do not render practically impossible or exercisable difficult to exercise the rights conferred by the common law principle of effectiveness. And the court elaborated somewhat on the measures of damages. So this is not only the relevant Italian court has now rendered a judgment that among other matters, awards claims double damages as means of giving effect to the court of judgment, but it has been suggested that this is not what the court intended. And further guidance is probably needed on the quantum of damages, and it is significant that the Court of Justice suggests that claimants have a right to seek damages for loss of profits as well. Yes, although the difficulties in showing a causal link between the infringement of competition law and the loss of chance to make profit seems unsurmountable, and it is likely that most claimants will settle for a claim of actual loss, that is, the overcharge caused by the cartel. According to another famous judge in the same case, that is Manfredi case, also set out the constitutive conditions of the claim. So, in this view, this means that the right of damage is available to any individual when there is harm and competition law violates and causal link between the violation and the harm. If this is correct, then two consequences follow. First, there is no need for the plaintiff to prove fault. Secondly, the more significantly, it means that both direct and indirect buyers may claim damages. Think, for example, for a cartel in market for MP3 players sold by the manufacturers to high street shops. The high street shop pays an inflated price. As a result, they try to pass some of the higher cost to consumer in the form of higher prices. It appears that a claim for damages may be brought by the shops and each individual buyer, which the Court of Justice has made a major contribution in establishing certain elements of the facility damages claims. And you have to keep in mind that the Commission has taken the view that further legislative efforts are required to ensure that the right of damages is exercised widely. So this is not only the matter of your legislative right, but it is also a matter of the European Union to enforce their legislation directly and indirectly on the national interest. So Bangladesh, if we look at Bangladesh as one of the European Union-based countries, then it is the focus of the European Union not only to apply the European Union legislation, not only to apply the European Union legislation on European Union court, European Union-based court countries, but also they must also ensure that okay, guys. So this is not only the very basis of this application is not only to apply the European law in the court survey, but also in other elements of the country-based local laws that are found in European Union countries. And it is the national courts which will focus on applying directly and indirectly all the European Union based laws. So you have to keep in mind that damages can be achieved not from the commission but also from the private individual too. So next class, what we will cover is the elaboration of the legislative initiative, direct and indirect practice from different phases of European Union law. So what I want you guys to study is go through the chapter of your subject guide in European Union, and also try to solve a question. I'm available after or before the class in my office. So if you want to show me, get any question checked by me, just give me a knock in Facebook or cell phone, or reach me face to face in person. I will get your answers checked. But however, it is very important, as you have just 1 or 2 months left for your examination, to prepare for the subjects. You must prepare answers to. Okay. So we'll then take it and we'll come back. Okay. So let's take a 10 minutes break and we'll come back and record things. Okay. So should I stop it or should it continue? Right, should you stop it?